Action dismiss.
May I please, your Lordship?
Yes.
Lordship, item number 4, Lordship. I will be allowed to withdraw.
Item
Item number 4. 4.
4.
4.
You want to withdraw it?
Lordship.
Mr. F. Hock, Learned Counsel for the applicant submits that he has an instruction to withdraw this application. Where is allowed this application is disposed of on withdraw.
Obliged.
May please, your Lord. My lord, I beg to mention item number 12, my lord. In this case, my lord, appellant number 3 died, but I have no instruction. So may I pray at least 4 weeks time so that I can take necessary instruction from my client.
You work for appellant.
Appeal.
Acha.
It may come up.
You work for respondent.
Respondent plaintiff.
Acha. Mr. S.K. Ghosh, Learned Counsel for the appellant submits that as per his information, the appellant suffered demise and he needs one week or 2 weeks.
My lord, 4 weeks, my lord.
4 weeks time
Because I
so
will
as
have to write
to
together.
enable him to obtain necessary instruction in this regard. The pair having not been objected by Mr.
J. Deppers.
Learned Counsel for the respondent number,
Respondents plaintiff. Respondents,
all the respondent,
not all for respondent, respondent plaintiffs.
respondent plaintiff. Pair is allowed. List the matter after 4 weeks.
1 to 5. Obliged.
May I please, your Lordship? Your Lordship, there is an urgent matter, your Lordship, for listing, your Lordship, as the matter for evidence has been fixed on Saturday, your Lordship, that is 17/8/2024.
Mm.
Here, your Lordship,
When do you want?
your Lordship, tomorrow,
Possible tomorrow.
as date has already been
One or
fixed.
two cases. One or two cases.
Okay.
Deeply obliged.
May I please, your lordship? I beg to mention item number 19, lordship. Lordship, kindly matter may be adjourned today and taken up after 3 weeks, lordship.
Item number 19.
Item number 19.
You are for
I am for the respondent.
respondent. You inform the other side?
Yes, lordship.
That's it. No objection. As agreed by learned advocates of both the parties, this is a list the matter after
After 3 weeks, lordship.
3 weeks.
Yes.
Okay.
2 weeks.
May it please, the Lordship. May it please, the Lordship.
Mhm.
Lordship, I beg to mention item number 1. This application was earlier rejected by Honorable Mrs. Justice Sushmita Pukon.
Mm.
So in view of that, Lordship,
Item number 1.
1 minute. Yeah. We have mentioned the earlier, we have mentioned the earlier bail rejection order also, my lord, at page 61 and 63. Page 61 is rejection order.
Okay. Recessalize the matter before appropriate.
I'm deeply obliged.
May I please, your lordship? My lord, in item number 21 and 22, these are two second appeals fixed for hearing today. My lord, I am just informed by the counsel for the respondent side, MS R. Chaudhary, that she has got some problem today. I am appearing for the appellants in these matters. Let it come after 4 weeks, my lord. It's a 2018 matter.
Mr. A. Dhor, learned counsel for the appellant with consent from the other side, press for listening the matter after 4 weeks.
My lord,
Fair allowed.
obliged, my lord.
May I please, item number 3, kindly adjourn the matter further.
Item number,
Item number 3,
why?
engage counsel out of session. Engage counsel out of session.
Who is your engaged counsel?
Motiur Ahmed.
Your good name?
M. Rahman.
M.
M. Rahman.
Your name
M. Rahman. My name.
and conducting counsel?
Motiur Rahman. My name is Moziur Ahmed.
Mr. M. Rahman, learned counsel appearing on behalf of Mr. Matiur Rahman, learned counsel for the accused. Press for listening the matter after
After 1 week.
1 week. Fair allowed.
Master.
May I please, Your Lord, I would like to mention for listing and McApple case,
When?
on 2 September, 2nd September.
Okay.
May it please your lord. My lord, with the consent of my learned friend, item number 2, my lord.
Hmm.
My lord, I am paying 1 week time, my lord.
Let us fix a date because it's a old matter, Lordship.
Record has already come, I think, my lord. Last time your lordship was pleased to call the record, my lord.
Can it be on 20, Lordship? 28,
28,
20 of this month.
20. Kobe?
All right.
Mr. Ziuddin, learned counsel for the respondent number 2 with concern from the petitioner. Press for listening the matter after a week. Where allowed to recess and list the matter on 28th.
All right.
May I please, Your Worship? Worship, I pray for listing and make a bail. Worship, can it happen on 20 of this?
Which item?
Listing for MSc appeal, Your Lordship.
When?
On 20?
Possible.
21st. Your Lordship. Deeply.
Your Lordship, I'd like to mention for listing MSc appeal,
When?
12
12.
or 12, 16. Sorry.
Possible.
Obliged.
For bail hearing, item number 5.
Lordship, case diary was called for.
We have not received the CD, Lordship.
Worship, can you fix a shortage? I'll be interested.
Mr. P.S. Lawford, learned additional fee submits that he has not received a case that he and price for granting him 1 week time.
Lordship.
Fair is accordingly allowed. Recess and list the matter after 1 week. In the event of failing to produce the case diary on that day, the court will proceed to hear and dispose of the application on the basis of materials available on the record. Till next date, interim order pass earlier shall continue.
Okay. Once we
22nd,
22nd.
25.
May it please your lord. One of the last occasion. On the first occasion, Lordship asks for the status report, including the notice to the private respondent complaint. By order dated 5th of August 2024. নাই তোমালোকৰ হেৰি নোটিচ দিব দিছে তোমালোকৰ যোগেদি পঠিয়াব প্ৰাইভেট ৰেছপন্সিবিলিটি আছে
Yes, Locker.
Lordship, I will take instruction whether it is served or not, Lordship, after some time.
That such matters, such an approach on the part of the public prosecutor cannot be simply taken and rolled.
Okay, we'll take it up in the second half
At two,
today.
at two,
At two, there is one VC with Itanagar bench.
I think then,
So after the VC, then
or
tomorrow.
let them get the final report, what they have done.
Okay.
মই আজি এখানে তোমালোকৰ যদি অসুবিধা হৈছে আজি কালি লোৱা গোটেই কালি tomorrow.
Mr. P.S. Locker, learned additional PP submits that he may be granted 1 day time to obtain necessary instruction in respect of service of notice upon the respondent number 2. Pair is allowed, recessal is the matter tomorrow.
Yes.
Item number 26 and 27 for orders.
Yeah, please, my lord. My lord, in both the cases, my lord, I am appearing for the claimants, my lord. And in my lord, MSC appeal 10 of 2000, both are arising out of the common judgment, my lord. In the accident, 2 person died. So there are 2 cases and ultimately by the common judgment, my lord, both the cases were decided. Against that, my lord, 2 different appeals were preferred, my lord. In MSC appeal number 10 of 2019, my lord, service is complete, my lord. MSC 10 of 2019, my lord, order dated 31/2020, my lord. Service is complete, my lord. P0, my lord, 31/2020, my lord. Order.
You are in MSC appeal number 180
In both
or
the
in
cases,
both the appeal
both the appeal and for the claimants, my lord.
payments.
Yes, ma'am.
This appeal is preferred by
Insurance company.
Bajaj Allianz, and I'm for National Insurance.
Appeal is preferred by the insurance company, my lord. There are 2 insurance company involved, my lord, but the Bajaj Alliance General Insurance.
so service in respect of MSC appeal number 10 has already been completed.
Yes, my lord, complete. And my lord,
And the respondents in those, no, in appeal number 10 is same with the appeal number 180 of 19.
yes, my lord, the driver is same, the owner and driver is same. And my lord, there are other respondents, my lord, to whom I am representing, my lord. So service is, my lord, complete, my lord. If lordship, only 1 person, my lord, respondent number in MSC appeal 180, my lord. Respondent number 4 is the owner cum driver. As per office note, my lord, the service is not complete on him, but he is the same person, my lord, in both the cases and in what 10 complete, my lord. And this is against the common judgment, my lord. So I pray that, my lord, service may be accepted and both the cases may come.
No, in item number, no, in MSC appeal number 10,
Yes,
respondent number 4 is same
same,
with this.
same.
So in item number 10, service in respect of 4 is also completed.
Complete.
Item number 10, Lordship, in fact, it was in 2020 itself, it was fixed for hearing.
Yes.
Heard, Mrs. R.D. Mazumdar, learned counsel for the appellant.
No, Lordship, I'm respondent. There were 2 vehicles involved. Bajaj Alliance has filed Mr. P. Pothakur.
You are for, madam, you are
I'm for,
for?
Insurance
in one, I'm for respondent number 3, in another, I'm for respondent number 6. In item
In
26.
item number 180,
Yes, I'm
No.
there, I'm 3. I'm respondent 3 there.
respondent number 3.
And in item 27, I'm respondent number 6. But the appeal is filed by another advocate, Lordship. I'm respondent.
So that advocate is absent today.
Yes, my lord.
Yes.
Let the service may be accepted and it may come up for hearing, my lord, on this. The lordship may take. fix
Okay.
the date.
Heard Mr. A.K. Gupta, learned counsel for the respondent number.
My lord, in MSC appeal number 180, my lord, I'm respondent number 1, 2, and 5 to 9, my lord.
1, 2, and 5 to 9. And Madam R.D. Mazumdar for respondent number 3.
3.
3.
Respondent number 3. None appears for the appellant on call. Mr. Gupta, learned counsel for the respondent number so and so submits that this MSC appeal number 180 of 2019 is analogous to MSC appeal number 10 of 2019 arising out of the same judgment and award. And in respect of MSC appeal number 10 of 2019, service has already been completed and the matter is ready for hearing. And as the respondents herein are same in MSC appeal number 10 of 2019, the service upon the remaining respondents deemed to be completed, and as such, both the matters may be fixed for hearing. In view of the submission of Mr. Gupta, learned counsel for the respondent number so and so, and as agreed by Ms. R.D. Mazumdar, learned counsel for the respondent number so and so, the SSL is the matter for hearing. In usual course,
My lord, lordship may fix a date, my lord, because they are in need of the money.
2nd of September,
Obliged.
3rd,
Hello.
3rd of September.
Obliged.
Okay.
Item 28,
May it please your lordship. Your lordship, inadvertently steps could not be taken upon the legal heirs of respondent number 3, your lordship. We may be given 2 days time, your lordship. We will take steps.
My lord, respondent number 3 substituted respondent has already appeared, lordship. My lord, service perhaps is completed, lordship. We are praying for fix the matter for hearing, lordship, because there is no interim order passed in this case also, lordship. She is appearing for substituted respondent, lordship.
How many respondents are there?
4 respondents, your lordship.
2.
Yes, 4.
Two.
Respondent number 3
Mr.
has
Khan, you are
expired.
for respondent number
I am for respondent number 1 and 2.
1 and 2.
Respondent number 3 has expired, your lordship, and they have been impleted, your lordship, already.
Already
I'm
included.
looking for the new respondents.
You are for respondent number
3, 1, 3, 2, 3, 3, and 3.
and respondent number 4.
Duly served, your lordship.
And he is the driver.
Order has been passed to that effect.
Your lordship, office note dated, your lordship, of MA Perus, office note dated 8/8/24, your lordship. As per process server report, respondent number 4 is duly served, your lordship. 8/8/24.
Hard miss,
P. Bodhapur,
learned counsel for the appellant.
appellant, your lordship.
And Mr. M. Khan, learned counsel for the respondent number 1 and 2.
One
And
and
madam,
K. Burma,
for respondent number 3, 1, 2,
3, 1, 2, 3, 4.
3, 4. 3, 4. None appears for the respondent number 4, though office note dated 8/8/2024 indicates that notice upon respondent number 4 was duly served. It is submitted at the bar that as the service completed, the matter may be listed for hearing.
There
Accordingly,
has been received, your lordship.
Office note dated 8/8/24 also indicates that the LCR has already been received. In view of above, recessal list the matter for hearing. In usual course,
My lord, I am praying for a date because there is no interim order passed in this case, lord.
okay,
On 19/9.
19th of September.
Oblige.
Oblige, your lordship.
29.
Lordship, the name of K.R. Patgiri may be reflected in the cause list.
Name of
Correspond- K.R. Patgiri.
K.R. Padgiri.
It's fine.
Okay. Recessal reflect the name of Mr. K.R. Padgiri, learned counsel for the respondent number 31234.
31233.
Yes, Alex.
So this my lord transfer petition, my lord, by the wife, my lord, for transferring, my lord, petition filed by the husband for seeking divorce.
Hmm.
And on 25th of June, my lord, lordship kindly see the order, my lord, 25/6/2024. They proposed for, my lord, amicable settlement. They did not make any communication with the petitioner.
Hmm.
And thereafter, my lord, matter was listed on 15/7, they remain absent. And on that day, my lord, this honorable court, my lord, observed that we may seek liberty to first stay order, my lord, of the further proceeding of the proceeding. Next date fixed on, my lord, 20th of this month, my lord.
We'll fix a very short date.
Today, my lord, 13, next date is 20, before the trial. My lord, till then, my lord, the further proceeding of divorce proceeding may kindly be stayed, my lord.
Oh, wait, can we take it up on 16?
16. Monday. Okay. 16. Yes, Lord.
Heard Mr.
Okay.
Arale, learned counsel for the petitioner. None appears for the respondent on call. Mr. Ali, referring to the order dated 25/6/2024, submits that on that day, the learned counsel appearing for the respondent advised the court that there was a talk for settlement outside the court. And on account of the aforesaid submission, the case was adjourned till 15/7/2024. But on that day, the respondent remained unrepresented. Today also, the respondent remained unrepresented. Recessal is the matter on 16. In the event of non-appearance of the respondent number 2 on that day, appropriate order shall follow. We'll dispose of
It will
the
be listed in admission column. In admission column, my lord.
Okay, admission column.
Items for hearing. Item number 6, Parthad matter. Item 6.
पुनः सुनाएगा सब कॉल करते हैं
Item 7 and 8. Parthad matter.
for succession. Yes,
On that day, the lordship put me some questions regarding the nomination and entitlement by the first wife.
Mm.
The- There are some judgments of our High Court, my lord.
Mm.
And I want to cite, my lord, the plus 2003 ZLT, 2003, 3 ZLT, column 3.
listen, my lord. Just be.
2003, volume 3 ZLT, page 400.
Is the copy available with you?
Yes, sir, book, sir. Well, your lord's.
Refund वाला account पे.
Of paragraph 15 and 16, my lord.
Yes, any other law?
The other judgment, my lord, 2009 3 ZLT,
Hmm.
page 153, my lord. The paragraph, I refer paragraph 17, my lord. In
Hmm.
respect of, while the first wife is living, my lord, then nomination also, that cannot be done in respect of any other woman, my lord. As the rules is, Assam Services Pension Rules is very much very clear in this regard, that only the eldest surviving widow is entitled to the pension, and no nomination in respect of other that can be made.
So this appeal is against the.
Admittedly, well, the respondent is third wife. my lord. And third wife, my lord, has no locus standi to file any succession certificate also, my lord. Because so far, third wife is concerned, my lord, it is
So
a
this appeal is for revocation of the succession certificate.
yes, ma'am. Yes, ma'am. The third wife doesn't have any locus standi to file any application for seeking succession, my lord. Because in respect of third wife, it's a void marriage, my lord. She doesn't have any status as a wife, my lord, and cannot succeed any property of the husband. Only illegitimate children may seek such application, my lord, seeking succession certificate. And in this respect, my lord, her petition is absolutely silent whether she got any progeny or not, my lord.
So under section 383 of the Succession Act,
Appeal lies, my lord.
no, the conditions have been mentioned under which the succession certificate granted earlier can be revoked.
Yes. Revocation, my lord.
Yes.
And a 384 is, my lord, appeal. I have filed an appeal, my lord, against the granting of succession certificate. In respect of respondent, I was not made party. And the second, my lord, the revision application has been filed against the succession certificate granted to me. And please that respondent has not been made party in that civil revision. And I cited some decision, my lord, no civil revision lies, my lord, in respect of it, because the provisions of appeal is their statutory appeal, my lord. And overriding that provision, my lord, Article 227, that cannot be maintainable. That was the submission on the earlier day I made. I cited the one decision also in respect of the motor accident claim tribunal. Revision was filed instead of exhausting the provisions of appeal. Pension rule is very clear, my lord.
Yes, Mr. Bora.
So I want to refer, my lord, section 137, my lord. Here it is specifically stated, my lord, the eldest surviving wife is entitled to. You lordship may kindly see.
No, Mr. Sururi,
Yes.
mainly your prayer is to revoke the succession certificate granted to the respondent.
Yes, my lord. I am submitting in the context, my lord, in the next revision application, my lord. He has.
No,
filed-
no, one by one. Let us first complete this appeal.
Yes.
Yes, Mr. Bora.
This is a petition challenging the grant of my succession certificate. Therefore, this is not a challenge that who is entitled to pension. So basically, the grounds of revocation of a certificate is given in 383.
Yes.
That is the grounds.
Yes.
Firstly, that the proceedings to obtain the certificate was defective. That is not their ground. The certificate was obtained fraudulently by making a false suggestion or by concealment from the court or something material to the case. But that is also not a case that I was aware of their first marriage. That is not their pleaded case. That a certificate was obtained by means of an untrue allegation, fact essential in the point of law to justify the grant. Though such grant allegation was made in ignorance or inadvertent. The certificate has become useless and inoperative. That is also not a ground. That the decree or order made the competent court in a suit or other proceedings with respect to effect compromising debts or securities specified in the certificate renders it proper that the certificate should be revoked. Lordship, neither of the grounds, some suppression of material facts is made in the pleadings, but it is not substantiated by any document, Lordship. Firstly, so none of the grounds for revocation of a certificate is mentioned in the pleadings, Lordship.
Say this is number 2. Ground number 2.
Clause number 2, Lordship, there are certain allegation of suppression, but it is not supported by any material. Lordship, in my petition, I have alleged suppression of material facts with evidences and documents that she knew that I was there. Still, without making me a party, without informing the authorities, they have obtained the succession certificate. But in her pleadings, Lordship, there is an allegation merely, but it has to be the.
No, we are now hearing this appeal now. What is your submission in respect of the appeal, not in respect of the revision petition preferred by you?
Yes. So, Lordship, I am making the submission that clause number 4, clause number 2, I will read it out. For the respondent suppress he material facts that the deceased was the husband of the appellant, his property was situated at village Bokolia of Nalbari district to choose the jurisdiction of the court. Accordingly, the respondent committed fraud in seeking succession certificate being not legally married wife according to the orders granting the succession and the extended succession certificate are illegal and liable to be set aside. Lordship, firstly, for an allegation of suppression of material fact, it has to be preceded by a statement that I was aware of it. Lordship, there is nothing on record to show that I was aware of the first marriage. And my marriage, a son was born out of it. Therefore, my marriage, Lordship, I did not know, Lordship, that he is legally. Therefore, there is a statement, but it is not supported by any material evidences, Lordship. That is my case, Lordship. Secondly, Lordship, and a submission has been made regarding the first entitlement of the first wife or in the third wife, Lordship. This is a case for revocation of a succession certificate, whether who is entitled, Lordship, that is something else. And the para number 2.
No, Mr. Bora, now you see, she is the first wife.
Yes.
So while applying the succession certificate before the court said default, so she was admittedly not made a party.
Lordship, I was the first one who applied for the succession certificate. I was the one.
No. Who is first? I am not asking you. Admittedly, she is the first wife.
Yes, Lordship.
So she has not been made a party in the application for succession certificate, and no notice was issued to her also. Right?
Yes, that is true. But Lordship, there is no statement that I was aware. Secondly, Lordship would see at para 2, Lordship, I am again referring. The appellant and his property is situated at village Bokolia at Nalbari district. Balikoria, sorry. Now, Lordship, the property here means, Lordship, to assume jurisdiction, the court, the property mentioned in the succession certificate should be there in the district, firstly. Secondly, or at the time of his death, she should reside over there, Lordship. The property in this succession certificate is the pensionary dues to be at default PWD office. Property here does not mean, Lordship, the immobile property. There can be different succession certificates for different properties, Lordship. These succession certificate, Lordship, I will show it. Lordship, I will show at page 9 and 10, Lordship would kindly see 9 and 10.
No, that's all right. On the other day, you have shown it.
Yes, Lordship, therefore, Lordship, that
No,
statement,
the question before the court is where it is not the question before the court that where the property is situated. The question before the court is whether
notice
the
was issued.
condition mentioned in section 383 are fulfilled.
Lordship, yes, notice was not issued.
Hmm.
Notice had to be issued.
Hmm.
In that case, it is defective.
Then is it not a ground to revoke the succession certificate?
Yes, Lordship, but the same ground applies to me also. I was not made a party.
Hmm.
Then both both succession certificate would go, Lordship, in that case. Lordship, yes, Lordship, the first wife, if any claim is there of the first wife, she should have been made a party. That is there.
Okay. Now come to the this revision petition.
Yes.
Yes.
No, it has- Now, Lordship would see that in my pleadings,
Hmm.
I have specifically stated at page 10, para 12(5), why I have opted for the alternative remedies. Actually,
At page number
10, para 12(5). Lordship,
yes.
there is a, Lordship, I'll read it out and explain. That there is an alternative remedy in section 384 of the Indian Succession Act, but the remedy available under the statute is not equally efficacious in the present facts and circumstances of the case, as the petitioner is claiming the retirement benefit through a writ petition. Initially, they filed a writ petition, which was not known to the present petitioner within the prescribed time of appeal. As such, a process of filing appeal under 3 would be lengthy and it would cause prejudice to the petitioner. If any effective order is passed in the writ petition number so and so. Moreover, the remedy sought in this application is on the ground of violation of natural justice and order passed in excess of jurisdiction. As such, it qualifies as an exception to the alternative remedy as observed by the Constitution bench of the Apex Court. As such, the application is maintainable in the present form, and Honorable Court may be pleased to pass an appropriate order staying the order of the district judge and the succession certificate dated so and so. Now, Lordship, these pleadings has not been objected to. Lordship, this is a writ jurisdiction.
Where is the judgment of Supreme Court?
Yes, Lord. Lordship, I am coming to the judgment. Firstly, I like to place that this is a writ petition under 227. A writ petition, if not objected to by an affidavit, Lordship, is a settled law that any averment not objected in the pleading stands admitted, firstly. Secondly, the ground of challenge is jurisdiction and violation of principles of natural justice. Therefore, in my pleading, I have specifically stated that it is an exception to the rule of it is an exception to the rule. Therefore, Lordship, if it is not objected to, whether at the time of hearing, Lordship, that plea can be taken, Lordship, that is another question. Lordship, now there is a judgment, 2003 5 SCC.
No,
399.
you first produce the judgment you have referred to in paragraph number 12.5.
Yes, yes. The judgment referred in paragraph number 12, it is a math, the same exceptions are there, but it is under 226, their judgment is 1961, so AIR 1961. What I am referring to is specifically under 227. The same exceptions are there, but it is 227. Therefore, this judgment is more applicable, Lordship. Therefore, I have got the judgment.
Which one? This one?
This one. 2000. The judgment that I have referred to that relates to a writ of 226. Lordship, it is settled that if a statutory remedy is there, we have to first apply to the statutory remedy. But in certain exceptional cases, Lordship, we can directly approach the writ court. Paragraph 9. Paragraph 13, Lord, to be precise. Uh, 13. Even otherwise, the view taken by the division bench of the High Court for repealing the objection of the appellant regarding the maintainability of the writ petition that an alternative does not divest the High Court of its power to entertain petitions under 226 and 227 of the Constitution has hardly any application to the. It is settled a long catena of decisions that when a receipt or liability is created by a statute which itself prescribes the remedy or procedure for enforcing the right or liability, resort must be had to that particular statutory remedy before seeking the discretionary remedy. Under Article 226 of the Constitution, the rule of exhaustion of statutory remedies is no doubt a rule of policy, convenience, and discretion, and the court may, in exceptional cases, issue a discretionary writ of certiorari. Where there is complete lack of jurisdiction for the officer or authority or tribunal to take action, there has been a contravention of the fundamental rights, or there has been a violation of the rules of natural justice, or where the tribunal acted under provision of law which is ultra vires, that notwithstanding the existence of alternative remedy, the High Court can exercise its jurisdiction to grant relief. Lordship, that is my case. This order has been passed in complete lack of jurisdiction and in violation of the principle of natural justice. May I read again the offer? The rule of exhaustion of statutory remedies is no doubt a rule of policy, convenience, and discretion, and the court may, in exceptional circumstances, issue a discretionary writ of certiorari where there is complete lack of jurisdiction for the officer or authority or tribunal to take the action, or that there are contravention of fundamental rights, or there has been violation of the rules of natural justice, or where the tribunal acted under a provision of a law which is ultra vires, then notwithstanding the existence of the provision of an alternative remedy, the High Court can exercise its jurisdiction to grant relief.
That is in respect of Article 226.
Lordship, in that fourth line,
227 is different.
Lordship would see 226 and 227. Fourth line, Lordship.
No, maybe where it is stated both are lying.
Lordship, fourth line, Lordship would see para 13. Even otherwise, the view taken by the division bench of the High Court for repealing the objection of the appellant regarding the maintainability of the writ petition and alternative remedy does not divest the High Court of its power to entertain petitions under 226 and 220 of the Constitution has hardly any application to the present facts and circumstances of the case. Lordship, I have also brought one note.
No. This observation is made by the Supreme Court only in respect of Article 226. So how can you apply in respect of Article 227?
Lordship, both, Lordship, both are rich jurisdiction. Firstly, Lordship, from the book of D.D. Basu, Lordship, I have.
No, you first tell me, can certiorari, writ of certiorari be issued by the court under section 227?
Lordship, may I read, Lordship, page number 1559. Lordship. This is specifically regarding 227, Lordship. It is from the second volume, Shorter Constitution of India, D.D. Basu, Lordship. এখন ধারক দিও আৰু এখন আছে sorry. But unless the alternative remedy is a speedy and effective as the remedy by way of application under 227, there could be very few remedies so speedy and effective. The mere existence of an alternative remedy cannot preclude the High Court from exercising its power under 227 to interfere with an order in flagrant violation of a law. A suo motu power of statutory revision has been considered as an adequate alternative remedy. Again, the rule of alternative remedy is only a consideration for exercise of jurisdiction and does not exclude the jurisdiction of the High Court in exceptional cases. Thus, in exercise of its power of superintendence, the High Court is bound to interfere in cases of absence or excess of jurisdiction, infringement of fundamental rights, where the law gives justification or to the tribunal is ultra vires and unconstitutional violation of natural justice. These are the four exceptions where, in spite of there being an alternative remedy, Lordship, writ of certiorari under 227 can be issued.
Okay, we'll see. Mr. Sodhuri, on the other day, you have referred one decision 2003, 3 SCC 524.
Yes, my lord.
Have you given the copy to me?
Yes, my lord. I had given my lord.
Lordship, I'll just highlight few pages of my petition that how the Lordship is taking up item number 8 because I have.
No, this CRP.
CRP. Just point it out for a moment. At page 14, Lordship would see that before applying for the succession certificate, at page 14, 8, in addition to this applicant, if any other person has take claim to receive the amount, then the name and address of the person, Rupali Baglari, has take. Lordship, there the authorities have clearly mentioned on an application made by her that I was also there, but still I was not made a party. Now, Lordship would see at page 26, Lordship, to Protima Datta, that is the petition.
Page
26. You are hereby asked to submit the relating documents regarding family pension case of late Harikanta Datta. Sri Rupali Datta Baglari, wife, of already submitted all the documents relating to the family settlement for settlement of the case. Therefore, you are hereby requested to submit the same for the date of issue and the later. Otherwise, the case will be settled as per the direction of the Diffu court. Therefore, here also, she was made known that I was also there. But Lordship would see at page 35, that is, the judgment starts from page 35. I was not made a party. Now, Lordship would see the respondents. The respondents are sons and daughters of the second wife, who were the respondents. The share of the succession certificate, as per page 40, was also given to them. Lordship would see paragraph 19. 19, Lordship would see at page 40. In view of the findings arrived at the foregoing issues, I find that the petitioner, being the wife of the deceased, and the OP 325 being the son of the deceased of the second wife, are entitled to the succession certificate of their respective share. All 5 children, OPs number 1 to 5 of the deceased and his wife, Sri Provita Datta, shall be entitled to 1/6 of share of the amount 351,791. As mentioned in the schedule of the petition, the petitioner shall be entitled to 3/6 share of the amount mentioned in the schedule, and the petition for herself and her children, that is OP number 1, 2, 3, and 5, shall be entitled to 3/6 of the share of the amount mentioned in the schedule of the petition. Now, Lordship would see that it is clear that succession certificate share was given to them also, but here also, in this petition also, they are not made a party. Lordship, if today Lordship suppose interferes with the petition, that Lordship, they will also be deprived. Lordship. That is also a defect under 383. Lordship, adequate notice to the stakeholders should be given to me also and to them also. Secondly, Lordship would see, I have from page 42, page 43 to be precise, 42 is the evidence in affidavit of Roman Datta in the succession case. Now, Lordship would turn to page 43 at para 8, last part. He is the brother of the deceased. But last 4 lines, but during this time, petitioner Pratima Datta never went to the hospital for a single day and visit Harekanta Datta so and so to Diffu from GMC, and Shintu took treatment of the father Harekanta and Harekanta died at Diffu. Brothers and sons cremated Harekanta Datta at Diffu and Bhuj at Balik Kakoria, but Pratima Datta was not present for a single day during all this time. Now, that is the evidence. What I wanted to show, that my last, I died on Diffu, the property is in Diffu. So the district judge at Nalbari had no jurisdiction at all to grant the succession certificate. Lordship, now again, Lordship Tarulata Datta, the evidence of the auntie, Lordship. At page 45, page 46, Lordship would see the same thing is given at para 8. Now at page 48, it is the deposition of the son Suman Datta. At page 49, at para 8 again, the same thing has been repeated. Therefore, it is evidently clear that the Lordship, I will show at my page 52. Page 52. Name of the debtor, executive engineer, PHC Diffu Rural, WS Division. Now, Lordship, these are the property. Now, property would mean this only, Lordship. This property is situated at Diffu, and I died in Diffu. Now, Lordship would see 371 for a moment. So I'll read it out. court having jurisdiction to grant certificate. The district judge within whose jurisdiction the deceased ordinarily resided at the time of his death, or if at the time he had no fixed place, the district judge within whose the jurisdiction any part of the property of the deceased may be found may grant a certificate under this part. Lordship, he ordinarily resided at Diffu. He worked at Diffu, therefore the second part would not be applicable to him. Therefore, he resided in Diffu, he died in Diffu. Firstly. Secondly, let us presume the first part is not applicable. Then also, as per the second part of the definition also, it has to be in Diffu, Lordship. So, the district judge of Nalbari does not have any jurisdiction, it's my humble submission. And Lordship, I have already shown that it is in violation of past in natural justice, and it meets the grounds that is there in 383. Lordship, I have other judgments, one or two, Lordship, which shows that a judgment passed without jurisdiction is nullity in law. Lordship knows.
Okay, we will submit it to the court, Master. Heard Mr. Rishi Chaudhary, learned counsel for the appellant in testamentary appeal number 3 of 2020, and Mr. B.P. Bora, learned counsel for the
I want to make reply in regard to revision application, my lord, regarding locus standi, my lord. The section 5 of the Hindu Marriage Act, my lord.
Section 5 of?
Section 5 of the Hindu Marriage Act. 1955. 5, I refer 5(1), my lord, sir.
Yes.
A marriage may be solemnized between any two Hindus in the following conditions if the following conditions are fulfilled, namely, neither party has a spouse living at the time of marriage. Next, your lordship may kindly see section 11, my lord, void marriage.
No, Mr. Chaudhary, there is no doubt about it.
My lord, already the marriage in respect of third wife, that is void. So whether the third wife is a necessary party, he is stating about non-making of the non-impleading in the succession case at Nalbari, and he hails from Nalbari. His property is there at Nalbari, so that jurisdiction lies there. And she is a third wife, admittedly, and her marriage is void. Whether she has any locus standi to file succession certificate, that is a question. This is my submission. If marriage to whom it is null and void, the marriage is null and void, she has no entity at all to file a succession certificate, application for a succession certificate. And her entire action is a fraudulent, my lord. That is my humble submission before this honorable court. And regarding 227, my lord, under 227, it is a corrective jurisdiction of the High Court, only in respect of the abuse of process, and for other error, my lord, the court can extend jurisdiction under Article 227, and no certiorari can be issued, my lord. In this respect, my lord, there are two decisions, my lord. Suryadev Rai and my lord, there is another decision also, my lord, where it is specifically stated. I will submit both the decisions, my lord. 227, my lord, there cannot be any certiorari direction of those. And apart from this, my lord, the revision application is not at all, my lord, maintainable in respect where it is statutory provisions are there for filing appeal, my lord. This is my humble submission. I have submitted one judgment also, my lord, regarding motor accident claim tribunals.
That's under law judgment.
Yes, my lord. And apart from this, my lord, if pension rules is seen, my lord, then also, my lord, no nomination can be made in respect of a person who has a void marriage, my lord. I can,
Uh,
I can cite
Lordship,
this judgment also.
There is a judgment.
yeah, item number 8, you take the
2027 SCC 327.
heard Mr. B.P. Bora, learned counsel for the petitioner, and Mr. Vishwas Chaudhary, learned counsel for the respondent. Argument concluded, judgment reserved.
Sir, number 9, pardon matter for hearing.
Yes.
My lord. So for my lord, applicable of the section 4 of the, my lord, Probation Act of Offender Act, my lord. My lord, I have searched, my lord, but I have not found, my lord. In 307, my lord, it may not be applicable, my lord, because I have found a judgment, my lord, which was, my lord, conviction under section 326, my lord. So that was also life, my lord. And in that case, Honorable Supreme Court, my lord, so only, my lord, I have supplied another judgment of the Honorable Supreme Court, my lord.
Yes, Mr. Laskar.
I am on that lordship, as per section 4 lordship. Section 4 clear specifically says lordship when it is, if it is not punishable under punishable with death or imprisonment for life lordship. As it is there, here is a life is imprisonment is there lordship, then it will not attract lordship. Section is very much clear lordship.
Unless I have supplied a judgment of Honorable Supreme Court 2019, Criminal Law Journal, model 397. On earlier date, I have supplied criminal law.
Oh, okay, we will see. Heard Mr. Ziuddin, learned counsel for the appellant, and Mr. Lawford, learned additional PP for the respondent. Argument concluded, order is judgment reserved.
All right.
At number 10, pardon matter.
Made visual lordship. So I am submitting all the citations and it cannot go back.
I also submitted written submissions along with the judgments.
Heard Mr. S.R. Gogoi, learned counsel for the appellant, and Mr. P.S. Lawford, learned additional PP for the respond. Argument concluded, order is judgment reserved.
Obvious.
Applies.
Yes, Mr. Locker, your good name, please? For respondent number 2.
No,
Yeah, respondent number
For informant, my lord.
informant.
So number 11,
May it please your lordship. Lordship, here respondent number 1 has expired.
Mm.
We need to file a substitution petition representing the legal heirs of respondent number 1.
You are for appellant.
Appellant
Your good name?
D Devi.
Miss P Devi.
D.
T. Heard Miss P Devi, learned counsel for the appellant, and Mr. A Borua. A Borua, learned counsel for the respondent. Miss Devi submits that respondent number 2.
1.
No, respondent number 1 suffered demise. And she will file an application for impleting the legal heirs of the respondent number 1. And press for granting her 2 week or 1 week.
2 weeks.
2 week. Pair allowed. Huh? How about you?
on 16/9.
Obliged.
Public.
Item 13,
May I please your lordship, I'm appearing on behalf of Advocate U Chakravarti. She is actually, she's not doing well. So I would be appearing for the hearing on the next date also. Your lordship, I would ask for, let me be allowed to submit a written argument in this matter with all the relevant judgments. A time may be granted, your lordship.
Lordship, on last occasion also this matter was listed before your lordship.
Mm.
And today the matter is fixed.
Your
Lordship,
I
this is
just
a very
looked at the
old
file
matter
yesterday.
and the appeal is not material, Lordship. So Lordship, if permit Lordship, the matter may be fixed on 22nd of August, Lordship.
20th maybe,
28th will be.
22 is Tuesday. 20. Next Tuesday.
Generally, it's not required,
Is,
Lordship, because it's
uh,
a very old matter.
In the first week of September, you choose any date and take it from him.
3rd September, your lordship.
3rd September.
No, 3rd September, I have left.
on 5th September.
5th September. Obliged, your lordship.
As agreed by learned advocates of both sides, Resisal list the matter on 3rd of September.
June 5th.
5th of September.
Obliged, obliged.
Item 14,
Lordship, I pray for time being, your Lordship. Uh,
15,
You are for respondent.
Respondent. Last of the.
Appellant is absent.
On last occasion, your lordship recorded their absence also.
What to do?
No, otherwise, my lord,
Dismiss
What-
for default.
there is the
None appears for the appellant on call on today also. However, Mr. R. Ali, learned counsel for the respondent present. Mr. Ali. Submits that. On previous occasion also, the appellant remained absent without any step. And in view of the conduct of the appellant, the matter may be, the appeal may be dismissed. But considering the submission of Mr. R. Ali, learned counsel for the respondent, and also considering the conduct of the appellant, this court find no just ground to adjourn the matter to another date, and accordingly the same stands dismissed.
not interim order will back it.
Interim order passed earlier stands vacated.
Okay.
item 16,
My lord, herein the sole respondent has passed away in April 2024, your lord. So he has to be substituted, your lord. So in that regard, then IA has to be filed here.
Appellant,
Appellant,
none appears for the appellant on call. However, Mr. Day, the learned counsel for the respondent, present. Mr. Day submits that respondent number,
the sole respondent, your
the sole respondent suffered demise.
lordship.
And Who will file application? The appellant side?
They have to file, I'll provide them the names of the legal representatives, but they are not present, Your Lordship.
Suffered demise. However, as it appears from the record, no step has been taken by the appellant or impleting the legal heirs of the respondent, sole respondent. Be that as it may, list the matter after 1 week. In the event of subsequent non-appearance, appropriate order shall follow.
Much obliged.
17 and 18.
Your Lordship, I pray for time being as senior counsel is on leave.
Time being.
Item 20.
Lordship, I pray for time being. My senior is on leave.
Who is your senior?
Iqbal.
Item 23.
Lordship may kindly pass over this matter for the time being, but the opposite side is not there.
You are for the appellant.
Appellant, Lordship.
Appellant is insurance company.
Insurance company, Lordship.
Item 30.
None appears for the appellant on call. List the matter after 1 week. Okay. 31.
Your Lordship, is same as earlier, date may be fixed here for submitting written argument, Your Lordship.
About to okay. You are for respondent. here.
Respondent, railway. Your Lordship and advocate you.
Appellant is absent today.
Yeah, appellant is absent.
None appears for the appellant on call. How Miss so learned counsel for the respondent present and press for listing the matter when
5th of September.
5th of September. Fair allowed.
32.
It's also same, Your Lordship.
Same. Okay. Same. But we have to fix on different date.
On 19th September.
19th September. Obliged, Your Lordship.
Part 9. Part officer. Judgment दिया असल है हाँ तो मुझे लेडी वासन संपर्क
Appellant side is having some difficulty today. There is some urgency in the matter, otherwise also Lordship, I made a mention for listing. Can be taken up any day in the next week, probably this 22nd or 27th. 27th. 27th.
The first week of September.
Lordship.
5th September.
First week of September.
Can a date be fixed, Lordship?
Yes.
On 5th September.
As agreed by learned advocates of both sides, registration is the matter on 5th of September.
Coming item 14.
May it please your Lordship, and this is an appeal under Workmen's Compensation Act, Lord. In this case, original appellant has died and his wife has been substituted. And the substantial question of law framed on 11/9/2012 is 1 and 2, my lord. I think 2 will be sufficient, whether the learned commissioner was justified in assessing the loss of earning capacity himself when the medical practitioner not assess the loss of earning capacity in accordance with the provision of section 4(1)(c)(2) of the Act. In this case, the claimant's nature of injuries, claimant sustains multiple injuries on his right leg and right hand arm. Claimant exhibited the disability certificate where it has been shown that 40% disability, but no loss of earning capacity has not been assessed. And the learned commissioner himself has assessed the loss of earning capacity at 100%, Miller. That is the illegality, Miller. As per Act, the qualified medical practitioner has to be assess the loss of earning capacity, Miller. The commissioner has no power to assess the loss of earning capacity.
Okay. This act. Right.
So here the injuries.
Workman Compensation Act.
Oh. And the injury sustained by the claimant is not a scheduled injury.
Not a?
Scheduled injury. As per WSEC, it is not a scheduled injury. Therefore, the loss of earning capacity has to be assessed by the qualified medical practitioner. Your Lordship may 4.1.
No.
4.1C2.
No. The substantial question of laws were framed under Workmen's Compensation Act. This is Employees
It
Compensation
was
Act.
amended. It was amended later on, my lord.
When?
In the year 2000, 2030.
2009, man.
Earlier, it was Workmen Compensation
Yes.
Act.
In 2009, it was renamed as
Employees Compensation Act, 1923.
The sections remain same.
Same, my lord. Only name is changed.
Section 4.1C2, my lord. Under the WSA, disablement is of two types. One is permanent disablement, another is total disablement. Permanent disablement is permanent partial disablement and permanent temporary disablement. And the in case of where permanent partial disablement, section 4.1C, my lord, where permanent partial disablement result from the injury, it has to be mentioned in the schedule, my lord. In the case of an injury specified in part of schedule, such percentage of the compensation which would have been payable in the case of permanent total disablement as is specified therein as being the percentage of the loss of earning capacity caused by that injury. And the injury are
That
mentioned.
schedule is in the Act itself?
Yes, my lord.
There are several schedules. So which schedule is relevant here?
Schedule 1, my lord. Schedule 2, my lord, result in permanent partial disablement. And then the nature of injury sustained by the claimant does not fall under this category, my lord.
Schedule 2.
Schedule 2, permanent partial disablement.
In which clause it is stated?
schedule to, but injury is not mentioned in this schedule. Therefore, the injury, therefore the injury, loss of earning capacity has to be assessed by the qualified medical practitioner, my lord.
Yes, Mr. Gupta.
I have citation also in this.
The person who suffered in the accident was the driver, man. He has suffered injury in his legs. There are multiple injuries, my lord. And my lord, there is a medical board. After assessing the person, has issued the certificate by saying that there is 40% disability, my lord.
Medical board.
Medical board, my lord.
That certificate is available in the
Yes, my
record?
lord. The certificate is exhibited as exhibit, my lord. Exhibit 4, man.
It's from the record in the database.
Exhibit 4.
Exhibit, no, exhibit 4.
Exhibit 6, man. Exhibit 6. Disability certificate.
So, whether the commissioner has issued, no, framed any issue on this point
Yes.
in the judgment?
Issue number 7, my lord, page 10,
Issue number 7.
page 10. A doctor was not examined, my lord, in this case. Though the certificate produced by the injured workman certified that he suffered permanent disablement of 40% as his physical disablement, but from the evidences on record and the documents submitted by the applicant, I am of the view that total permanent reduction in earning capacities to the extent of 100% has resulted, as the injured applicant will not able to work as a driver throughout his whole life, my lord. That finding is wrong, my lord.
How?
Because Commissioner himself has assessed the 100% loss of earning capacity that he cannot do as per Act, my lord. It is the doctor who has to assess the loss of earning capacity, my lord.
No, if the medical board has assessed it, then
No, in this case, doctor was also not examined, my lord. They just exhibited the document only.
Mm.
And we did not get any scope to cross-examine on this point also.
Mm. There is some judgment how to assess the disability. There's Rajkumar versus Ajay Kumar or like that.
That judgment is not with me, but Honorable our High Court has assessed that if the doctor has to be assessed the loss of earning capacity, means there are several judgments on this point, my lord.
My lord, I'm relying on this judgment, my lord. Paragraph 28, my lord. Paragraph 28.
Yes.
Very much. In the light of the aforesaid decisions and the definition of the term total disablement as provided by clause 1 of subsection 1 of section 2 of the Act, it is the functional disability and not just the physical disability which is the determining factor in assessing whether the claimant, that is workman, has incurred total disablement. Thus, if the disablement incurred in an accident incapacitates a workman for all work which he was capable of performing at the time of the accident, resulting in such disablement, the disablement would be taken as total for the purpose of award of compensation under section 4(1)(b) of the Act, regardless of the injury sustained being not one as specified in part 1 of the schedule of the Act. The proviso to clause 1 of subsection 1 of section 2 of the Act does not dilute the import of the substantive clause. Rather, it adds to it by specifying categories wherein itself we deemed that there is permanent total disablement. So, my lord, my submission, at that time, the person was working as a driver, my lord. And due to the number of the injuries in his leg, my lord, it is not possible for him to drive, my lord. And even under the Motor Vehicle Act, he is not entitled for license because his foot movement will not be normal, my lord. So that's why my lord commissioner has assessed the compensation by treating him as permanent disability, my lord.
Milord, in this regard, there has to be finding, Milord, that the claimant suffered injuries which incapacitates him to do any other work which is capable of at the time of accident, Milord. And in this regard, I am also relying on the judgment of this Bimal Nath, Milord, where it has been stated that the doctor has to be opined that he is incapacitated to do all the work.
So details procedure has been laid down in that case, Rajkumar versus Ajay Kumar, like that. That judgment is of after this judgment, perhaps. What is that judgment? And
Ajay,
Rajkumar versus
that
Ajay Kumar, like
judgment
that.
is not with me. I will provide in that.
Pardon?
The judgment is at present not with me, Milord.
Pardon?
Ajay-
Supreme
Ajay-
Court. Supreme Court.
Ajay,
Rajkumar versus Ajay Kumar, like that.
but here the loss of earning capacity has to be assessed by the qualified medical practitioner, Milord. Without the
No, here only mentioned that as assessed by the qualified medical
Yes.
practitioner.
and our High Court judgment in New India Assurance Company Gopal Shil, Milord, paragraph number 7, Milord. The learned counsel for the appellant has submitted that in the present case, the doctor did not assess the loss of earning capacity, and therefore there being no assessment of loss of earning capacity by the doctor, it was not open to the learned commissioner to assess the loss of earning capacity in the absence of any valid certificate to that effect. It is further submitted that the loss of earning capacity must be assessed not only on the basis of the income of the injured respondent number 1 in his capacity as a driver, but such loss must be in relation to any other employment which the respondent number 1 was able to carry out for his livelihood. It is further submitted that the appellant could not have been first in the liability to pay penalty from the date of accident, and as such award can only become due from the date of default in paying the liability arising out of award passed by the learned commissioner. In support of our argument, the learned counsel for the appellant relied on the order dated so and so passed by this court in the case of New India Assurance Company Paltu Shah. By relying on the said judgment, he submits that as the facts in both cases are similar, the substantial question of law framed by this court in the present case can be answered in terms of such judgment rendered in case of Paltu Shah. It would be relevant to refer to paragraph 7 to 11 thereof, which is quoted below. This court finds force in argument of Mrs. Choudhury, which is based in the ratio laid down by this court in the case of Sanjit Kumar. By the said judgment, this court has held as follows: the Workmen's Compensation Act provides the mode and method to determine the compensation. The court cannot adopt some mode or method which is not provided in the act. In the portion of the award quoted above, the court determined the percentage of loss of earning capacity at 50%. That power is not available with the commissioner. So this award shall stand first, and the matter now shall go back to commissioner to assess the compensation afresh. And in order to do that, he may even ask the doctor to appear before him and give his opinion with regard to percentage of loss of earning capacity. In view of the said ratio as laid down by this court is of the opinion that as regards the first substantial question of the commissioner under the act does not have power to make its own assessment of the loss of earning capacity of its own without there being any medical evidence in that regard. And this is the first substantial question of is answered in the negative and in favor of the appellant in terms of laid down in case of Sanjit Kumar. Then your lordship may come to another judgment. New India Assurance Company versus Tarun Chandra Das. Paragraph number 10, my
So
lord.
these are all High Court judgments. What is that judgment? We will see. And their discretion is given to the tribunal also to assess the disability.
But evidence is to be, they have to admit.
Even though the medical board or the doctor assess the,
In this, the doctor has not been examined, my lord.
yeah.
Yeah, doctor.
All
has not
right,
been examined.
even
Only
though the
disability
doctor is not
certificate.
examined, the tribunal may assess it
Um,
on the
tribunal-
basis of the documents produced.
tribunal, Commissioner may not assess the loss of earning capacity, money as per the act, my lord. That power is not with the learned commissioner, my lord.
Hmm.
And that is the wrong committed by the learned commissioner, my lord.
No, we'll examine the matter in the light of the decision of Supreme Court. What is the decision on next that we'll keep it as part third. Third miss
That's right.
Esra, Learned Counsel for the appellant, and Mr. A.K. Gupta, Learned Counsel for the respondent. List the matter on COVID. First week of September,
Second week of September, Lordship, on 12th September.
12 September as part third.
Coming item 20.
May please explain. Well, this appeal is against concurrent findings, my lord. And the appeal was admitted, my lord.
Hmm. Where is the substantial question of law?
My lord will find order dated.
Fifteen to 19.
15 to 19.
15 to
15 to 19, my lord, 4 substantial questions of law were framed.
Yes.
My lord, the respondents hearing, my lord, they filed a suit seeking declaration of right title interest,
Hmm.
recovery of possession in respect of Schedule A and B plot of land, and permanent injunction. The suit was allowed by the learned trial court. Being agreed, my lord, the present appellants, they filed an appeal. That
Suit was
decreed, my lord.
Hmm.
Suit was decreed, that is at page number, my lord, we'll find at 30. Page 30, trial court's judgment. Page, sorry, relevant portion is important, my lord. I'll just point out one thing, page 35. Why
Yes.
It's important, my lord. The order part, in the result, the plaintiff suit is decreed on contest with cost by declaring right title of the plaintiff over the entire Schedule A land and over 1/4 part of the Schedule B land. It is further declared that the defendant number 3 and performer defendants do not have title of more than 3/4 part of the land described in Schedule B of the plain. The defendants are custodians of Schedule A, B, and C schedule land are liable to surrender their possession to the plaintiff. Although, my lord, there was no prayer for recovery of possession of Schedule B plot of land, but the learned trial court, my lord, has said that custodians of Schedule A, B, C plot of land are liable to surrender their possession to the plaintiff. A decree for recovery of khas possession of Schedule A and B schedule land by evicting the defendants is passed. My lord, the defendants, the plaintiff, they sought for a declaration over only 1/4 part of the Schedule B plot of land. But the recovery of possession was given over the entire Schedule B plot of land. Although, my lord, if my lord sees this,
Where is the plaint?
plaint will, my lord, find at page number, the amended plaint is at page 24. And the prayer portion is at page 26.
Yes.
11A, 11, that the plaintiff therefore claims and prays for a decree declaring that the title of the plaintiff over the entire land of Schedule A and over 1/4 part of the Schedule B land. So 1/4 is there, my lord. AA, a decree declaring that the defendant number 3 and pro forma defendants do not have title of more than 3/4 part of the land of Schedule B. A decree declaring that the defendants being not any heirs or successors recognized by Mohammedan law and being mere custodian during the lifetime of Keshmati Deva of Schedule A and B plot of land are liable to surrender possession to the plaintiff. A decree of khas possession for recovery of the land of Schedule A and B, evicting the defendant, their heirs and agents. So if, my lord, the declaration is sought only for 1/4 of the Schedule B land, then, my lord, recovery of possession could not have been given in respect of the entire.
So in the order, it is mentioned over 1/4 of the part of Schedule B land.
But, my lord, the last part, a decree for recovery of khas possession of suit A and B schedule land by evicting the defendants there is passed.
No, in the first part, it has been mentioned clearly 1/4 part of the Schedule B land.
Declaration is given, my lord. Declaration is given in respect of 1/4 only. But the recovery of possession is given only in respect of the entire Schedule B plot of land. So that is what my contention is, my lord. If the declaration is given only in respect of 1/4 part of the Schedule B land, then the recovery of possession should also have been given for only 1/4 part of the Schedule B land, because that is also reflected in the prayer portion, my lord.
Yes, madam.
No, lordship, thereafter first appellate court judgment is also there. He may point out the entire suit before your lordship. What are the plaintiff's case? What are the reliefs granted by the first appellate court or trial court, lordship?
But the first appellate court has concurred with the findings of the trial court. Lordship has not given any independent finding.
It's a second
That's
appeal,
what-
lordship. You may read the entire judgment, then your lordship's conception will be clear, lordship. Let him read the entire judgment, lordship. There are some findings in the issue-wise findings, lordship. What is happening to what?
No, after perusing the order
Lordship,
in the judgment, it is apparent
lordship.
that in respect of the recovery of possession of suit A and B schedule land by evicting the defendant is passed. It ought to have been in respect of 1/4 part of the B schedule.
Exactly.
Lordship. That will, lordship, prayer portion, it is already there. Only 1/4 part is claimed by the plaintiff's, lordship. And declaring the right title, when right title is 1/4, lordship, how decree can be over the entire land, lordship?
But it is mentioned.
But lordship, the entire 1/4 will be only granted to the petitioner's lordship, plaintiff's lordship, only because their boundary was also mentioned over 1/4 land, lordship.
That's why, my lord, my submission is a fit case for remand, my lord. My lord may fix a time period, my lord.
No, lordship, for that, lordship, I have to argue the entire case. Before that, I think, lordship, it will be better if he goes by the entire case, lordship.
No, that's all right. But if it is apparent on the face of the record that some mistake is there, then
No, for that, lordship, amendment can be filed. 152 provision is there, lordship. For that, we can pray for correction of the decree through 152 lordship, CPC. That is their lordship. Any clerical mistake or any lordship identification of the suit lane, if any defect is there, lordship.
No, can it be termed as a clerical mistake?
No, lordship, the decree part, it can be amended, lordship. Only order portion, it is reflected that the recovery is A, B, and C lane, lordship. That can be corrected by 152. For that, lordship, entire judgment has not to be, lordship. Again, lordship, contested by both the parties. Lord. It is a suit of lordship in the year 2001.
Is it the only grievance, your grievance?
No, there are other aspects also, Mike.
So I am, lordship, submitting that he should, lordship, submit the entire case before your lordship. This is maybe one of his point. The
I'm ready to
substantial
submit, my
question-
lord, but this is the error apparent on the face of the record. So if this is also decided, my lord, so it will remain even if other points are also not taken into account.
That can be corrected, lordship, that for that, if he is agreed, if I am going to evict him from the entire land, for that he can also file 152 application and I can also
My
file.
lord, the
lordship.
judgment was passed way back in the year 2013, my lord. Till date, they have not filed any application for seeking rectification under.
No,
section
lordship,
152.
execution, that is, can be done before the executing court, lordship. For that rectification, I have not.
No, executing court will go by the decree.
Lordship, executing court is the competent court, lordship, to decide every objection, lordship. There are so many judgments of Supreme Court, lordship. Regarding lordship, Pratibha Singh is also there regarding identification of the suit length, lordship. It can be corrected by way of an amendment application before the executing court also. And suit is of the year 2001, lordship. Now we are in 2024. Both the courts
No,
decided in our favor.
this court has to see whether there is any substantial question of law or not.
Yes, lordship.
But perusing of this order, it is apparent that there is substantial question of law, while there is pair for only
No,
1/4 of
lordship, what
the
are the substantial
schedule.
questions of law, lordship? The substantial questions of law on which the appeal was admitted, lordship. Whether the judgment and decree suffers from misreading, non-reading of the pleadings and evidences, as well as misinterpretation of the documents adduced by the parties, and as such resulted in wrong and perverse findings in deciding the vital issue number 5.
So is it not a perverse finding?
Lordship.
Because pair is only for 1/4
Lordship.
and the decree is passed for entire
No,
land.
right title, when there is a right title.
Maybe,
only
but
over
position is
1/4.
given.
No, lordship, right title is given only over 1/4, lordship. Only
But
1/4.
position of the entire land.
For that, lordship, every issue is to be looked into, lordship. For
Pardon?
all the issues are to be looked into, lordship. Whether the findings given by the trial court and
No,
the.
no, no, no. All the issue only we will deal with only the substantial question of law that has been framed by this court.
Then, lordship, I will argue on that point only. If your lordship only wants to decide that substantial question of law number 1, then I will.
No, no. The other points are also there.
Lordship.
All the substantial question of law we have to decide.
Lordship, for that.
Not only this.
If he argues on every aspect, lordship, later on your lordship can decide this question, lordship. If this is a regular second appeal, lordship, both the courts decided in favor of the plaintiffs, lordship.
Maybe.
Lordship.
If both the courts committed a mistake, then
Lordship, if perversity is there, lordship, the substantial question of law is there, lordship. I agree that even if there is a concurrent finding, the High Court can reverse, lordship. And I will satisfy your lordship with judgments that these are the mistakes can be corrected by way of amendment of the lordship, the suit length.
no, that is not the issue before this court.
No, only right title was given only over 1/4, lordship. How recovery can be given more than that, lordship? That is the only mistake, lordship, in the judgment. And there are so many decisions in some of the cases, even after giving right title interest, no recovery was granted in some of the judgments, lordship. That was later on corrected by 152, lordship. As the pleadings was there for recovery and it was not given by the court below, that can be corrected by 152. Even in one of my case, lordship, by 152, after 17 or 18 years, lordship, recovery of possession was corrected. And thereafter only the decree was executed, lordship.
Okay, then you produce the judgment, whether this can be corrected
Yes, lordship.
before the executing court.
Lordship.
Let us fix a short date then.
Lordship, any date, lordship.
Pardon me, sir.
Iqbal.
Iqbal, learned counsel for the appellant, and Ms. R. Chaudhary, learned counsel for all the respondents.
Yes, lordship.
Third in part, list the matter on
On 29th August.
for further consideration.
Deeply obliged.
Obliged.
Arrow. Condition. Last item to party radius. No, party radius. Sound patterns.
Coming on 23.
Obliged, lordship.
Deeply obliged.
And for the respondent number 2, my lordship, yesterday we cannot contact the respondent number 2, so 3 weeks time may be given, my lordship, for further instruction. I am the owner of the vehicle,
You are the?
owner of the vehicle. As I have already sold the vehicle, my lordship. So that's what it is.
So what instruction is required?
Instruction, my lordship, the agreement is not with us, my lordship, that's sale agreement, that is.
Okay, heard me, sir.
R. Goswami.
R. Goswami, learned counsel for the appellant. And madam,
I am B. Bhuya, my lordship, respondent number 2.
respondent number 2. Ms. Bhoya submits that she may be granted
3
2 weeks time.
3, my lordship. Yeah.
3 weeks time so as to obtain necessary instruction. Where is accordingly allowed, recess shall list the matter on
10th September.
10th of September.
Highly obliged.
Yes, my lord.
Yes.
Item 2.
My lord,
Yes.
my lord, I'm a counsel of the petitioner.
This IA is for what purpose?
All these IAs are filed by my lord, the respondent applicant.
IAS, yes, have been filed by the respondent.
So this IA number 39.
39, yes.
Yes.
But my lord, as of now, my lord, with the efflux of time, since this is from the 2019, my lord. Now the new elections have also been done and new legislative assembly has also been constituted.
Yes.
So basically nothing survives here.
So what is the period in this IA?
Prayer, my lord, one was for correction, my lord, that there was some typographical mistakes, my lord. And one is for, one was for liberty to adduce evidence, my lord, regarding the delay in the filing of the election petition.
So this was against the general election held in the year 2019.
2019.
Yes, my lord.
That assembly, the period of that assembly already elapsed and new assembly is constituted.
Yes, my
So
lord.
according to you this matter become infructuous?
My lord, since
Yeah. Is anything survived now?
my lord, since my lord, since here allegation is of the corrupt practice.
Yeah.
If during the trial, if
Unless
it,
it is decided, it will affect your career.
yes,
Is it?
yes, my lord. In case if he is found to be indulged in the corrupt practices,
Involved in yes.
yeah,
Corrupt practice.
then consequences will follow that he may be barred from contesting from election, my lord, in future.
But whether he is elected this time or not.
Elected, already elected, again, elected for the second time. Now, because my lord, otherwise the prayer is for setting aside the election, which has already been that Legislative Assembly of 2019 that has already been dissolved, and prayer is for again for election of this petitioner Dikto Yekar to that election to the 2019 Legislative Assembly.
Acha, anyway, in this IA number 39.
Yes.
Your prayer is to accord permission to adduce evidence in support of the ground of maintainability.
Maintenance.
Yes. So, Mr. Lazi, do you have any objection here?
Yes, my lord. My lord, I have filed objection in this IA also, and since my lord,
No, this IA is listed for the first time today.
no, my lord.
IA number 39.
39 is pending since my lord 2020, my lord.
20.
Yes, my lord. Actually, all these IAs were filed only to delay the, my lord, the proceeding of the main election petition, which they have very much succeeded. All these IAs. IA 39 was filed by the applicant for leave to adduce evidence in support of the maintainability. And second, in IA 227, here applicant respondent challenged the maintainability of the election petition. And in IA 37, here applicant respondent want amendment of their written statement. So, my lord, my humble submission is that since here election their contention in their written statement is that election petition is not maintainable, and that can be decided, my lord, with the main petition. And if instead of, my lord, summoning witnesses and this.
No, if they want to adduce evidence, they have to in the main petition.
Yes, my lord.
Lord, here, my lord, one.
Yes.
My lord, that maintainability we have raised, my lord, because as per our assessment, this has been filed beyond the limitation. It has been filed after the 45 days, after the expiry of the 45 days. And that those documents we have obtained from the registry of this honorable court, where the dates were overwritten. And further, my lord, this election petitions have to be personally presented.
Anyway, Mr. Lazi.
Yes, my lord.
Since Mr. Soki has raised the question of maintainability.
Yes, my lord.
So we have to decide it first.
Yes, my lord.
So if he want to adduce evidence, we have to afford him the opportunity to adduce evidence. Let him adduce evidence.
Yes, my lord. As the usual, please, my lord.
Because the question of maintainability has to be decided first.
Yes, my lord. But my lord,
Okay,
this.
Heard Mr. D. Soki, learned counsel for this applicant, counsel for the applicant, and Mr. Duyu Lazi, learned counsel for the respondent, opposite party. This interlocutory application is preferred by the applicant for allowing him to for according him permission stroke leave to adduce evidence in support of the ground of maintainability of the election petition. Number 8, within bracket AP 2019. As stated in the IA number 227 of 2019. Where is the application? And the documents enclosed therewith. Mr. Soki, learned counsel for the petitioner, applicant submits that the applicant is willing to adduce evidence in support of the grounds for maintainability of the election petition. Number 8, within bracket AP of 2019. As according to him, there are some overwriting in the.
Well, that the election petition was not presented personally, and it was filed after 45 days.
An election petition was not presented personally, and it was filed after 45 days. And where there is manipulation?
Well, that the documents that we have received from the registry, there is a overwriting on the date, the date of filing.
Where?
Has been in the document,
In the petition.
No, not in the petition.
No,
There is overwriting.
basically, my lord, the allegation is against our judicial staffs section of the.
Okay, we'll say overwriting of the date in the election petition itself. And therefore, Mr. Soki contended to allow this petition. Whereas Mr. Duyuladi, learned counsel for the respondent opposite party, has opposed the petition. On the ground that filing of this IA is nothing but an effort to further delay the matter. Further, having considered the submission of the learned advocate for both the parties and also considering the issue raised in this IA, this court is of the view that opportunity may be adduced. Opportunity may be afforded to the applicant to adduce evidence in support of the maintainability of the ground of maintainability of the election petition. Accordingly, the pair allowed this IA stands dispose of. So only for this IA, this case is listed today.
Yes, my lord.
Any order is to be passed in an election petition?
Election petition, my lord. Here also they wanted to amend the written statement, and I have filed objection with regard to that also, my lord.
In which IA?
IA 37.
37 to 2020.
37.
Yes, ma'am.
That, of course, to my humble submission, my lord, this can be taken up later after this evidence regarding the delay in the filing. Maintainability, that is taken up. Because if we succeed in that, my lord, nothing will survive. Otherwise, also, my lord, nothing survives, my lord.
Yes. So when do you propose to adduce evidence then?
My lord, we will file our list of witnesses, my lord, within 15 days.
When?
Within 15 days, my lord, we will file our evidence, list of witnesses, my lord. Basically, witnesses will be the staff of the registry only, my lord. The registry of this honorable High Court.
Acha.
We wish to call the staff of the registry, to ascertain whether it was filed within the time, within the period. That is So while we have prayed in the IA 39, which the lordship is allowed now.
So how much time it will take to dispose of the entire petition? If I go there for a week or two?
IA, my lord, since your lordship has already allowed this IA, my lord, we will call the witnesses for the maintainability, my lord. That can be taken up, my lord, regarding maintainability, my lord.
So are you ready in the month of September?
My lord, will be ready.
Yes, ma'am. List, my lord, they have already provided with this IA, name of the witnesses and all.
My lord, yes,
They
my lord.
have cited 4 witnesses.
In the petition?
Yes, my lord.
Acha.
In IA itself, they have mentioned the list.
Then we may fix a date for hearing.
Yes, my lord.
Examining the witnesses, my lord. Examination of the witnesses.
In view of the order passed in the IA number so and so, now the rest is the election petition. Election petition in the first week of September.
Yes, my lord.
Pending item 6.
Most obliged, my lord.
Yes. Have you find out that judgment of
That
imprisonment?
DP judgment I have not found, but I have gone through one bail of regarding section 42 by your lordship, where lordship had rejected the bail on facts are written on bail, lordship. I have gone through that only. But
Acha.
DB, I have also asked the public prosecutor, but they could not give me the name, etc. So I could not find it, lordship. Although I have asked the public prosecutor also, without name.
Then some judgments were with me.
Yes,
I am
lordship.
giving you the citation.
Yes, lordship.
You go through it.
Yes, lordship.
Yusuf alias Asif. Yusuf alias Asif versus State. Criminal appeal number 3191 of 2023. Then another judgments are there. That is Simranjit Singh versus State of Punjab.
Yes, Punjab judgments are there, lordship.
Criminal appeal number 1443 of 2023. And thereafter another judgment is there, Mangilal versus the State of Madhya Pradesh. And the main judgment is Mohanlal.
Mohanlal is with me.
So the view of the Supreme Court in this decision is that in view of the judgment of Supreme Court in Mohanlal case, this section 52A of the NDPS Act has to be complied with mandatorily. And if the prosecution side fail to comply with the same, then benefit of doubt may be extended to the accused appellant. So you go through the judgment, and you come prepared on next day. We will dictate the order. Heard, Ms. B. Sharma, learned amicus curiae for the appellant. None appears for the state respondent. List the matter on
22nd, lordship will be available here.
when?
22nd, Thursday.
27.
27.
27.
Yes.